Okay, in this video, we're continuing our discussion of AUC Section 250 for our consideration of the client's compliance with laws and regulations during the audit. And so, in this particular video, we'll discuss reporting of identified or suspected noncompliance with laws or regulations. And there are basically three different parties that we could report noncompliance to. That could be to those charged with governance. We could report it in our auditor's report on the financial statements. And we could also report it to regulatory and enforcement authorities. And so first, reporting noncompliance to those charged with governance, unless those charged with governance are involved with management or they're aware of what's going on as far as the noncompliance that we've already communicated to them, we should communicate with those charged with governance matters involving noncompliance with laws and regulations that come to our attention during the audit, and that's other than matters that are clearly inconsequential. So if it's something tiny and small that doesn't really need their attention or involvement, we can exclude that from our communications with them. But if it's something serious that they need to know about to administer their duties, we need to let those charged with governance know. And if it turns out that that noncompliance, we think that it might be intentional and material, and we should communicate that to those charged with governance as soon as practicable. So it wasn't just an oversight or an accident that they didn't comply with something that maybe training or something would help them to alleviate that risk in the future. If this is something that's intentionally and almost fraudulently being done by management, then those charged with governance certainly need to know about it. And continuing that further, if we suspect that management or those charged with governance are involved in that noncompliance, then we should communicate the matter to the next level of authority at the entity if it exists. And if no higher authority exists, or if we believe the communication may not be acted upon or is unsure about the person to whom to report, then we should consider the need to obtain legal advice. So if this is taking place at the middle manager level, then certainly we can communicate that matter to higher level management or those charged with governance and let them take care of it. But if it turns out it's noncompliance is happening at the top level of management, there's really no one that's monitoring them, then we need to consider possibly looking outside of the entity to report that to. And so next we might have to consider reporting that noncompliance in our auditor's report on the financial statements. But we remember that the goal of performing our audit and reporting on it is that we're looking for material misstatements due to either error or fraud. And so we don't directly report that there's been noncompliance occurring. Rather, we have to report that there would be a misstatement that is caused by that noncompliance. So if we conclude that noncompliance has a material effect on the financial statements and they didn't adequately reflect that in the financial statements, then in accordance with AUC Section 705, then we should express a qualified or adverse opinion on the financial statements in regard to the material nature of that potential liability or whatever the case may be that's related to that noncompliance. And if we're precluded by management or those charged with governance from obtaining sufficient appropriate audit evidence to evaluate whether noncompliance is material or is likely to have occurred, then we should express a qualified opinion or disclaim an opinion on the financial statements on the basis of a limitation on the scope of the audit in accordance with AUC Section 705 again. So if we're unable to get the evidence that we need to decide whether this noncompliance is material to the financial statements, then we have a scope limitation. We're not able to get comfortable over the financial statements in that regard, so we would have to disclaim or qualify our opinion to say except for X instance, or to say we're unable to get comfortable with the financial statements as a whole. And so if we're not able to make an opinion at all, and so if the auditor is unable to determine whether noncompliance has occurred because of limitations imposed by the circumstances rather than management or those charged with governance, then we should evaluate the effect on the auditor's opinion in accordance with Section 705. So finally, reporting noncompliance to regulatory and enforcement authorities. So if we've identified or suspect noncompliance with laws and regulations, then we need to determine whether we have a responsibility to report the identified or suspected noncompliance to parties outside of the entity. So for instance, if we're performing a governmental audit, we might have a requirement to report noncompliance with laws or regulations. So we've got some explanatory material here. I believe it starts at 26. Yes, A26 through A29. So let's go down to those sections. Okay, so now we're down to the explanatory material section for reporting identified or suspected noncompliance at the client that we're auditing. So first, regarding reporting to those charged with governance, when we do so, our communication might involve identified or suspected noncompliance. It may describe the act identified or suspected noncompliance, the circumstances of its occurrence, and the effect on the financial statement. So we may reach an agreement in advance with those charged with governance on the nature of matters that would be considered clearly inconsequential and thus need not be communicated. And you remember that would have possibly come about in the terms of our engagement, if you want to go back to those videos. Also, we had the possibility of issuing a modified opinion on the financial statements. So we could issue a qualified or an adverse opinion, depending on the circumstances. So if it says that management or those charged with governance refused to accept a modified opinion on the financial statements for the circumstances described in the requirements that we just went through, then we may withdraw from the engagement when withdrawal is possible under the applicable law or regulation, and indicate the reasons for withdrawal in writing to those charged with governance. So if it turns out we need to make a modified opinion, but management and governance disagree or won't accept that determination, then we might need to withdraw from the engagement entirely. And next, reporting to regulatory and enforcement authorities. So first, our professional duty is to maintain confidentiality of client information. Therefore, we might be precluded from reporting on this kind of information to people outside of the entity. However, our legal responsibilities vary by jurisdiction, and in some circumstances, we might have to report that kind of stuff because of a statute, the law, or courts of law. And a few times that we might be required to do that is in response to inquiries from an auditor to a predecessor auditor in accordance with AUC Section 210. So if a former client of ours goes to another auditor and the auditor requests for us to see the work papers of our last year's audit, then we might be required to provide those to these auditors. Of course, we would be getting permission from our former client to do so. We also might have to report this noncompliance in response to a court order. We also might have to provide this information for entities that receive financial assistance from a government agency. So, for instance, in single audits, we might have to report noncompliance. And so, since these responsibilities can be somewhat complex, and we're certainly not attorneys, we might need to consult with legal counsel regarding our responsibilities and obligations to report noncompliance to outside parties.